Good afternoon. The Memphis and Shelby County Board of Adjustment is hereby called to order for its regularly scheduled meeting on August 27th, 2025. My name is Tim Rainey. I'm chairman of the board. Mr. Jeffrey Penzis serves as secretary of the board. Mr. Penzis, may I get a roll call, please?
Mr. Bruce.
Present.
Mr.
You say Campbell?
Yes.
All right, present.
Mr. Claybrook.
Here.
Ms. Conrad.
Here.
Mr. Love.
Here.
Ms. Skurlock.
Here.
Vice Chair Savage Selden.
Present.
And Chair Rainey.
Here.
We have a quorum.
All right, thank you. The Memphis and Shelby County Board of Adjustment is the oldest appointed governmental body in Memphis and Shelby County. We were established in 1925. The board hears appeals from the administration of the zoning ordinance, requests for variances from the zoning ordinance, and other requests articulated by local zoning laws adopted pursuant to the enabling legislation. The 8 members of the board are appointed, 4 by the mayor of Memphis and 4 by the mayor of Shelby County, with confirmation by the Memphis City Council or Shelby County Board of Commissioners. We serve without remuneration. This time I'd like to swear in the staff. You may remain seated. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, thank you. May I get a motion to approve the minutes from last month's meeting?
So moved.
Second.
Any discussion? I did notice one quick change on agenda item 6 from last month. I was a recusal on that, and it shows me for it. So just we'll change that.
We'll make that up.
Okay,
Thank you.
perfect. All those in favor of approving the minutes as amended signify by saying aye.
Aye.
Any opposed? All right, the motion carries. Mr. Secretary, please provide us a secretary's report, if there is one this month, and then explain the procedure for today's meeting.
Yes, sir, Mr. Chairman. As for a secretary's report, there are no announcements this afternoon. The procedure for this meeting will be as follows. I will introduce each case as listed on the agenda. Copies of the agenda can be found on the front podium. For each case, the planner with the Division of Planning and Development will give a presentation. At the conclusion of the staff presentation, the applicant will have 5 minutes to present his or her case. After the applicant's presentation, those speakers in support will have a total of 5 minutes, and those speakers in opposition will have a total of 10 minutes. And then finally, the applicant will have 2 minutes to provide rebuttal. These times do not include times for or questions from and answers to members of the board. The chairman may provide additional time provided both sides are given an equal amount of additional time. All parties who wish to provide testimony to the board will be sworn in by the chairman. If a member of the audience wishes to provide testimony in support of or in opposition to a particular case on today's agenda, he or she will need to fill out a speaker's card for the record. Speaker's cards are available at the front podium. Once filled out, speaker's cards can be submitted to any DPD staff member at the left podium. We do not need speaker's cards from the applicant since their names are already part of the record. After all parties have been heard, the board will close the public hearing, make a motion, and then deliberate on the case. If the applicant or any speaker would like to be heard after the conclusion of the public hearing, or if a board member wishes to hear additional testimony from any party, a 2/3 vote is required to reopen the public hearing pursuant to the board's rules of procedure. Please note that once the public hearing is reopened, both the applicant and opposition will be allowed to provide additional testimony and or rebuttal. All motions made by this board will be made in the affirmative. The private acts governing the board require the affirmative vote of at least 5 members to approve an application, regardless of the number of board members present. The board may also vote to hold an application for a period not to exceed 3 months with the consent of the applicant or 1 month without the consent of the applicant. All section numbers that we refer to come from the Memphis and Shelby Unified Development Code, or the UDC, which was adopted by the Memphis City Council and Shelby County Board of Commissioners in August of 2010 and became effective on January 1st, 2011. I will introduce the entire UDC and make it part of today's record, thus dispensing with the reading of individual sections. The board is vested with the power to act on these cases before us today under the provisions of Chapter 9.22 of the UDC. Mr. Chairman, I submit that all cases have been filed in proper order, all applicants have been notified of this hearing, and all notice requirements have been fulfilled as required by the UDC.
All right, thank you, Mr. Secretary. At this point, the board will establish the consent agenda. To establish the consent agenda, the secretary will call out each eligible case. If any member of the audience, staff, or board member objects to a case being placed on the consent agenda, he or she should do so by a show of hands when the secretary reads that case. Once the consent agenda is established, the board will vote on all cases placed on the consent agenda as a whole and will not hold individual public hearings on those cases. Mr. Secretary, which items on our agenda are eligible to be placed on consent this month?
First, I would just like to note that item number 3 has been withdrawn. Item number 1, BOA 2025-66 at 2214 East Brooks Road as a hold for 1 month. Item number 2, BOA 2025-65 at 3614 Jackson Avenue as a hold for 1 month. Item number 6, BOA 2025-79 at 3654 Boxtown Road as approval with conditions. Item number 7, BOA 2025-82 at 1346 Bryan Street as approval with conditions. Item number 8, BOA 2025-83 at 7201 Bridgewater Church Road as a hold for 1 month. Item number 9, BOA 2025-84 at 10146 Rosemark Road as approval with conditions. Item number 11, BOA 2025-87 at 667 and 673 Stratford Road as approval with conditions. And that is it.
Okay, thank you. May I have a motion to approve the consent agenda as established by the secretary, which is going to be agenda items 1 and 2 as a hold, 6 and 7 approval with conditions, 8 as a hold, and 9 and 11 as approval with conditions.
So moved.
Second.
I would like to remind the board that by voting on the consent agenda, he or she affirms that he or she has read the staff report and is in full agreement with the conditions. Mr. Secretary, may I get a roll call, please?
Mr. Burse,
Yes.
Mr. Campbell,
Yes.
Mr. Claybrook,
Yes.
Ms. Conrad,
Yes.
Mr. Love,
Yes.
Ms. Scorlock,
Yes.
Vice Chair Savage Selden.
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey.
Yes.
Motion carries.
All right, thank you. If you're here for items 1, 2, 6, 7, 8, 9, or 11, you've either been held or approved as requested. Mr. Secretary, with that, will you please call our first case on our regular agenda?
Item number 4, BOA 2025-75 at 3629 Venable Road.
Okay, is the applicant present? Okay, thank you. Is there any opposition today? If the applicant, if you'll come down just to this front row and take a seat so we're ready for you, we're going to have the staff give a report real quick, then we'll hear from you. That's perfect. Thank you. All right. Whenever you're ready.
Good afternoon. This is Masano Stadnia with DPD. This is a variance from 262B2 to allow a group daycare home away from an intersecting arterial road more than 150 feet. The location is between American Way and also Lamar Avenue. It is zoned R6, and the surrounding uses are a mixture of single-family residential, commercial, industrial, and vacant lots. Here are a few photos of the property from Venable Road. The aerial photos show the industrial, commercial, and the character of the neighborhood. This is a site plan that the applicant submitted to us. The highlighted area is an additional section that the applicant added to this place. And per our analysis, we have realized this 25 by 20 feet section that was added did not get any legal building permits. We have four main concerns with this application. The approximate distance from an arterial road, which is Lamar Avenue, is 1940 feet, which is far more than what the UDC requires. Second one is, as mentioned in the site plan review, is the unpermitted section that has been added to the main structure, which is going to be used partially as a daycare as well. Third, this location is in the hazardous zone, as zone 4, which is a high-risk area for flooding. And the last is the location is in the middle of an industrial and vacant lots, which brings general concern for children who will be there for the daycare. Additional information, there's also a special use permit tied to this case. The denial of the variance would withdraw the application automatically. Whether the variance gets approved or denied, the applicant is required to file a building permit for the added section to the house. That being said, staff recommends rejection. However, if approved, this is the following condition. That concludes my presentation. Happy to answer any questions.
Staff? Okay. If the applicant will come forward. Yeah, come right to the podium, and if you'll state for the record.
Tina Green, 3629 Venable Road.
The true self you got?
I swear.
Okay, go ahead and talk to us about your project.
Okay, so I'm just trying to keep my children's. I can't do it because I'm 150 feet away from a main street. And the part that we are in that was closed in, that was my patio. I mean, flood area, we got plans, we got policies. I mean, if something happened, if a disaster happened, we got plans to move to another location.
Feet of like a certain kind of road.
Right.
You're like almost 2,000
In the back.
feet. Yeah. Like, so we've had some recently we've approved further away, but they were much, much closer or different circumstances. Like they weren't like, you're kind of having to go all the way through your neighborhood to the back, which is not
Right.
usually what you're supposed to do. How long have you have you already opened a daycare there, or you're hoping to open a
Yes,
daycare
it
there?
was, I was open once before, but I closed and I'll try to open back up now.
Okay. All right. Are there any questions?
I got a question. Is this a home daycare or is this treated completely as a separate daycare?
This is a what?
Like, is this a home daycare?
Yes, this is home daycare.
So you reside at the house?
Yes, I live there.
Okay.
Ms. Green, how many children do you normally
When-
occupy keep during the?
When I was open years ago, I could keep up to 7 to 12. But now, right now, I can only keep 4. What I'm trying to do is the 7 to 12.
Just for clarity, because she lives there, the UDC would allow her to have up to 7 by.
Okay.
Did you understand what he was saying? Because you live in the home, you're allowed to have at least up to 7. So if you have 4, you can add 3 more because you do reside
Okay.
in the home. Yes, ma'am.
And that's without a variance. That's just by right, correct?
Correct.
Okay. Okay, any other questions?
I got a question about the addition. The addition is to house kids as well? The addition to the house? The 20 by 20, the part that's in yellow, that was an
Patio.
addition? That was okay. And that
I
was,
just put walls and insulation in.
and what is the purpose of the area? Is that to house more kids or?
first, it was just my patio. But since I got sick and I was like, I got to do something, so I opened my daycare back up and I just put that area as my daycare
Okay, okay.
instead of inside my house.
Okay, yeah, I was just trying to get the correlation between what that space was in relationship to the rest of the house. Like if that was strictly for your personal usage or if the daycare
Yes.
is meant to be used in that portion of the house as well.
Yeah.
Yeah, so looking at this map, just so in front of the driveway or that area, the in green, that's, you kind of keep the daycare on the right side and in the old patio area.
Yes.
Is that right? And the rest of it, that's your
The rest of
private
the
area.
house is my house. That's
Okay,
where I stay.
gotcha. Okay,
It all connects. I mean,
okay.
it's a circle.
Any other questions or thoughts?
Can you talk about the difference it would make if you could go from 7 to 12 kids? I know.
I
it's more
mean,
money, but
7
just-
is fine.
Yeah.
Because I got, right now I'm keeping 4, like I'm splitting kids up. Some staying at home, well, a couple are staying at home, and I'm keeping 2 while we wait this process.
Okay.
So,
Okay.
If she does 7, meaning she doesn't need our variance here, does she still need to get the special use permit?
No.
Okay. She still needs to get a building permit.
I think, yeah, she'd need a building permit for that, and then I think the state would just ask her to file a CO where we would confirm the number of children is 7. That is
Okay.
correct.
So here's what, I'll give you my thoughts, and
Okay.
there's other people to vote. If you're okay with 7, you don't need us at all.
okay,
And I would rather not give you a variance in this location for more than what code allows. It seems like what code does allow will get you where you need to be. So
Okay.
I'm gonna vote no on this, because I think you can do it without us.
okay,
And so, any other thoughts on that?
No, that was my thought as well. If you mentioned 7 to 12, you can get 7 without. The only issue now is the fact that building code might still want you to get a building permit for the area that was constructed, but
Okay.
that shouldn't have any effect on your 7 capacity. But
so I can keep 7.
I think by right, she can do 7.
Okay,
Correct.
But I think you still need a building permit just because you built it without a permit. That's not really us
Okay.
telling you to do that. That's just like the city wants building permits for things that are closed in. So
Okay.
you'll need to do that, or else you could end up in environmental court or something like that over that non-permitted addition.
okay.
Okay. All right, any other thoughts? All right, so do we need to vote on this, or do we need to?
Unless she withdraws, we will need a vote.
Why don't you withdraw? When you withdraw your case, it doesn't, like, if we vote no, you can't come back and see us about this for like 6 months or something. You probably don't need to come back at all, but if you withdraw, it's kind of like you're dismissing it and saying, let's not talk about this right now. And if you had to come back because you needed 8, I'm not saying we'd ever say okay to that. It doesn't shut you down from doing that. So would you like to withdraw?
Yes.
Yeah. Very good. Okay, thank you so much.
All right.
All right, so Mr. Secretary, will you call our next case, please?
Item number 5, BOA 2025-77 at 1066 North McLean Boulevard.
Okay, is the applicant present?
Yes.
Okay, and is there opposition? Got some opposition, okay. All right, if we can get a staff report real quick.
Good afternoon. I'm Chloe Christian with DPD. I'll be presenting this case. It's case number BOA 2025-0077. The applicant is here with us today, Ms. Kaya Jefferson, and the property is located at 1066 North McLean Boulevard. There are 3 separate requests being considered here today, so I will go over them in depth throughout the presentation. So first, here's a location map of the property. It's located in the Valentine Evergreen neighborhood. So with that, there are additional design guideline requirements to be enforced with any new construction. So there is a corresponding COA case with this, which will be heard tomorrow. The property was built as a duplex in 1951 and unfortunately sustained fire damage in 2004. So it was demolished in March of this year. So the applicant is here today because your approval is needed for the three following things. One is a use variance to just allow the non-conforming duplex use. Two is a variance to allow the existing circular driveway. And three is a variance to allow 2 new front-facing garages. So overall, we are in support of the first 2 requests, primarily because these are 2 conditions that were historic to the home and existed without causing any detriment to the public good since the 50s. However, the third request, we are recommending rejection for multiple reasons, but predominantly front-facing garages are in violation of the UDC contextual infill standards and the Valentine Evergreen design guidelines. And secondly, the proposed garages are just not original to the historic footprint of the home. And we believe that there are some other options that should be considered that would be more acceptable, including some by right alternatives that I'll get into. Here is an aerial of the property and a land use map. I want to point out on the land use map, the yellow indicates single-family uses and the brown indicates multifamily uses. So this area can and does support a mix of uses. So the brown is likely some non-conforming duplexes that exist in the area. On the aerial on the left, you can see the original footprint of the home, including an extended driveway on the south side that would be a likely option for some rear or side parking to accommodate the duplex use. Here are some photos of the subject property. You can see the existing circular drive. But as of right now, the site is completely vacant. There's no structure on the property at all. These are the elevations and site plan that the applicant submitted. You can notice the 2 street-facing garages here. But I want to point out with this how deep the lot is and how that presents for space to incorporate side parking or rear parking, which could include keeping that extension of the driveway and having some sort of carport here to accommodate parking. This is the floor plan provided by the applicant. So from the contextual infill standards of the UDC, they're basically created to reinforce the traditional character and context of the surrounding area. So there are standards that apply to the lot width, setbacks, porch depth, and things of that nature. So the front loading garage is just taken from this section. And the standards do allow for street-facing garages if they meet certain criteria, but this criteria has not been met in this particular case. So street-facing garages would be allowed if an alley is not present and more than half of the buildings on the same block face have street-facing garages, or they would be allowed if they're located 100 feet from the right-of-way and 50 feet behind the front facade, which this case does not meet that criteria. So in conclusion, as I mentioned before, this would also require landmarks approval, and the Valentine Evergreen design guidelines strongly discourage street-facing garages, and so do the contextual infill standards. So ultimately, we do not find that this part can be supported. However, the first 2 requests for just allowing the duplex and maintaining the circular drive, we are in support of. So we recommend approval of those 2 requests with the following conditions and rejection of request 3. And I'll pause to read, and I'm also here for any questions. Thank you.
you say that you did recommend, I see that there is a carport, so were you saying that a carport would be more welcome than the closed garage, is that correct?
Basically, yes. So, open carport on one side would probably be preferred alternative than what's currently presented with the two front-facing garages.
Can they do an open carport by right, or would they need a variance for even a street-facing carport?
Variance.
Okay, all right, thank you. Any other questions for staff? Okay, if the applicant will come forward. If you can state your names and address for the record.
Good afternoon. My name is Kaya Jefferson. My address is 1066, 1068 North McLean Boulevard.
Okay, go ahead. And you too, sir.
Good evening. My name is Dominic Tompkins.
Give your address, please.
I didn't hear you.
Could you give your address, please?
My address,
Yes, sir.
meaning the address of mine.
Wherever you live,
Oh,
or can get mail. Yeah,
Okay, my address is 3870 Potterwood, Lakeland,
perfect.
Lakeland, Tennessee.
Okay, do you both swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead and talk to us about what you're looking to do here.
Basically, I lost my house to a fire in December 2024. I applied for the permit to get it demolished in March of 2025. It was basically considered I couldn't fix it how it was. It had to be demolished. So I had to start over. I got that approved, and along the process, he's my representative. He's been helping me to get this back on the road. I reached out to VECA and I got those guidelines, and we built it based on those. Later on, when I submitted for the code enforcement, that's when I got the rebuttal back that I couldn't have the front-facing garages. So I didn't really understand that in the beginning. I do now, but based on the layout of my home and the circular driveway, which was already there, it just makes more sense. And how my driveway is far back from the street. It's about 45 feet from the sidewalk to the interior vertex of the driveway, but considering where the garages would start, that would be further than 45 feet.
Okay. Besides the garages that you would like, do you have any other issues with these conditions?
No, I don't.
Okay. The one that we've had the most issue with, just so you know, is people that, that building the house up 18 inches above grade. Like a lot of people are like, oh yeah, we can do that. And then they come back, 6 months later because they built it flat with the ground. But that means it's got to be 18 inches up above grade. I'm only telling that because we've had it happen several times in some of the historic areas where people haven't done that. And they just didn't quite understand it. So you probably fully understand. I just want to make sure on that one.
I think I do understand.
Yeah, so you're
the
gonna
crawl space would
you're gonna need
be into
steps.
that.
You just think you're gonna need 3 steps to get into your house. So as long as your house is roughly 3 steps up, you should be good.
Yeah, the previous home had about 2 to 3 steps on both sides.
Perfect. Yeah, but we've just had people where they just come in and just lay a foundation like 2 inches above grade, and that didn't work. So just wanted to kind of go over that. Okay, so are there any questions for the applicant?
Yeah, let me ask. So I understand that you would like to have the garages on the front. Would it be impossible? Is there a real problem with moving the garages to the back of the side? Can you talk about why that would be a hardship for you?
Well, based on the floor plan, I don't have really much room to have the garages on the side. They could be on the back, but that side wouldn't really be.
We actually don't have the space to put the garage where you can have the turnaround. If you put it on the side, you won't be able to bag out and turn around, and we won't meet the setback requirements.
Thank you.
Page 8. How much room do we think you need, between a garage and a fence for a back out turnaround? Do we have like a standard for that, a rule of thumb?
There's not a standard, but I think you would, you probably need a little bit more than 10 feet or so. Yeah, but the 10 feet is, roughly the minimum we would request for a drive anyway, but I think if, that gets tight for the turnaround, but it is doable.
Okay.
Can I speak?
Oh, yes, sir.
And to add to that, most setbacks in subdivision, and I think in this subdivision, you got to be at least 5 feet, 5 to 10 feet from the side of the property line. So when you add the 5 feet to 10 feet from the property line and have the 10 to 15 feet to get in there for the turnaround, you actually need about 25 feet over there to make it work.
You can put a driveway all the way up to the fence.
Say it again?
I believe the concrete for the drive, there's no setback, side setback for that. You can't build like a house within 5 feet, but you can have concrete on there.
Right.
So you could use that space.
What I'm speaking of is the setback, the side of the house to the property line.
So right now, I guess you're right at that.
You're right at that.
Minimum requirement.
Right, we're right at that.
Okay. So, and even if so they're right at 5 feet on both setbacks.
Yeah.
So they have
Oh, no, they would have to reconfigure the house and have the garage further into the back. Then, you take this section, move that bedroom there, and then build on the back.
Yeah. Quick question about the carport. You mentioned the carport would have to come back for a variance if it's a carport. Is that an easier approval of approving a carport over a garage?
I think it would be the same as the garage.
Okay.
Like a porte cochere would be allowed, but that's where you can drive right through it. Like a lot of historic homes have.
I'm with you. Okay.
Any other questions for the applicant? We have some opposition, so you have time left over. Yes, you have like 8 minutes to rebut. So let's see what the opposition says, and then y'all come back and talk to us, if that makes sense. Okay. All right, so I'm going to see Mr. Bacchus. Do you want to come talk to us first? Do you want to give your name and address real quick?
Brian Bacchus, 5320 White Diamond Street, Memphis, Tennessee, 38109.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead and share it with us, sir.
Thank you, Mr. Chairman, members of the board. Good afternoon to you. I am here today to represent Valentine Evergreen Community Association. On this case, the Valentine Evergreen Community Association is very concerned about this development and another development that is it will be on your agenda later on. This application before you today for 1066 and 1068 North McLean, it's in the Valentine Evergreen Community Association, but more importantly, it's in the Valentine Evergreen Historic District. Next slide, please. In 1996, I believe, the Memphis City Council and the Land Use Control Board recommended approval of this land use map. And this is the existing land use map. As you can see, the subject property at that time was the land use was a duplex. Next slide. And the future land use for this area and that particular parcel is single family. So we're going back about 28, 30 years ago when the Memphis City Council and the staff at Planning and Development, as well as Land Use Control Board, saw a vision that this area should convert to single family. Those homes that are duplexes, some of those areas should be converted to single family. This is an opportunity, the exact opportunity to allow single family at this location. Next slide, please. So in that comprehensive plan that was approved in 1996, there was summary and conclusions. And this is in addition to Memphis 3.0. This is a plan to be considered in the zoning text, in the zoning code. So the following summary points provide a basis for a neighborhood plan and implementation. Concentration of duplexes, increased activity, parking problems, and traffic congestion in areas that were not designed for intensive uses. This can often detrimentally change the character of neighborhoods designed for single family. So the future of VECA, the general planning recommendations in the plan examine methods to develop a long-range plan to convert duplexes to single family. These are all in that plan that was adopted by Memphis City Council in 1997 and presented to that council by our colleague Jimmy Covington. Next slide, please. These are the photos of the site. These were taken yesterday. As you can see, the upper left, the entire frontage of the site. Lower left is the north property line adjacent to the single-family home. Upper right is the south property line adjacent to the adjacent home to the south. And the lower right are existing homes in the area that are primarily 1.5-story split-level type development. So there are opportunities for single-family homes with split-level design. Next slide, please. The UDC provisions of the code, new development should be, or any subsequent development, any new building or other structure, or any use of land should be constructed or developed in accordance with all the applicable provisions of the zoning code. No excavation or filling of land or construction of any public or private improvement shall take place or commence except in conformity with the zoning code. If the use variance is allowed for two-family, any development shall comply with the UDC provisions for single-family attached two-family housing type, garage and carport placement, semi-flush, side-loaded, setback and detached garages, contextual infield standards for front, side, and rear setbacks, the height of garages, the carports, front porches, and ground elevations. Access management, we're talking about residential driveways, the width and the extension of the driveways, and the location of the driveway. Location and the number of parking spaces for this particular unit, it requires 4 required parking spaces. Next slide. These are all in line with what the staff has recommended today, and we want to appreciate the recommendation of the staff. And I will not read this for you, but the use variance, and to sum this up, the property does not reveal any unusual characteristics. So a single-family land use permitted by right in R6 historic district zoning is practical because no unusual characteristics are found to apply to this property, including the existing physical site improvements. Next slide, please. So in conclusion, the VECA plan recommends those concentrations of duplexes to be converted to single-family homes. The duplexes detrimentally change the character of the neighborhood. In the future, the planning recommendations to examine methods for long-term program to convert duplexes to single-family homes. If the variance is allowed, any new development should comply with the provisions of the code. A single-family residential land use is a practical use at this location, and no unusual characteristics are found to apply to the property for a duplex. Any new development shall comply because the plan submitted is preliminary in nature and should illustrate more details for the board to consider before taking any action. Next slide. That's the end of my presentation, Mr. Chairman and members of the board. I'll be happy to answer any questions you may have.
All right, thank you, Mr. Bacchus.
Thank you.
Are there any questions for Mr. Bacchus at this time? All right, thank you much. And then I have another card here from Ms. Walker. Is Ms. Stephanie Walker here? She yields? Okay, thank you. So those are my 2 cards. Was there anybody else that wanted to speak in opposition to this particular case? Okay, ma'am, yeah, if you'll come forward and give your name and address for the record.
My name is LaToya Walker, address 1642 Central Avenue, Memphis, Tennessee, 38104.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, go ahead, Ms. Walker.
All right, I'm speaking in regards to Kara Jefferson. She is my daughter. She was born and raised in that neighborhood, and particularly on that street on North McLean, which has not changed whatsoever. There's multiple duplexes on that street, and it has remained consistent throughout the last 30 years. And I'm 48, and I pretty much say 48 years When she bought that home, it was a
All right,
duplex.
hold on. You're
Yes.
in favor of it, or you're
Yes,
against
I'm in
it?
favor of
Okay.
her rebuilding the
We're
duplex.
not in that section yet.
Okay.
So just hold tight. We'll come back.
Okay.
Don't worry.
All right, I'm ready. All right, thank
Yeah,
you.
we're still in opposite. Now, you may just be, don't go too far, because I
Okay.
don't think anybody else wanted to speak in opposition to this.
Okay,
So we're gonna move back to, we need to set a timer for what we're doing on this.
okay,
So you're in their rebuttal time, but I think you'll have plenty of time. So,
okay.
how much do we have, like 8 minutes or something? So it's actually 10 minutes. I don't think y'all need that, but go ahead. Just want to make sure we're in the right
Okay.
section.
All right, yes, we could all say that neighborhood has been pretty consistent. And so I'm just, for the duplex being rebuilt. And I respect the VECA committee, and I know what they're trying to do, but the population of Memphis is changing, and I'm just in agreement, and hopefully you will grant her to rebuild the duplex.
Okay.
Thank you.
Thank you so much. All right, if the applicant, you all want to come back up and rebut anything that you heard or add anything to your testimony?
I completely agree with what my mom said. I see what VECA is trying to do with transitioning those duplexes to single-family homes, but Memphis population is increasing, so I believe that we will need like the room in that area. It's so close to downtown that people will want to move into that area. So I hope you all will grant me my duplex back. If I need to change the garages, I will do that.
Okay.
But I would like to keep them as the floor plan that I presented.
Sure. Yes, sir.
Yes, and I would like to add, speaking of the garages, I actually rode the neighborhood, and within walking distance, it was at least 10 front-facing garages there. And they've been there for some time. It's not something that's just added. They've been there for some time. I can't remember the exact name, but the street, this
North Rainbow, South Rainbow, East Rainbow, Edward Street, Edward Cove.
just on those streets there, you have front-facing garages, and it's not like we're trying to come in and try to change anything. Now, we're actually trying to add value to the property. If you look at the duplex, you'll see that it is a very, very nice duplex. It's not like we're just trying to come in and throw up something that's going to devalue the neighborhood.
Okay. Any questions or comments?
I have a question. I know you said that you live in one of the duplexes. Do you rent, or was the other one rented prior to the burn, or did you?
It was getting ready to be rented. No one was in the home at the time.
Okay. And so the intent is for you to live on one side and then rent the other side?
Yes, ma'am.
I have a question. I just want to give you a chance to explain any hardships that will come for you if you have to convert it to a single-family home. I understand rental income is one, but aside from that, is there anything else that we need to know about that would any of the hardships that would result from you having to convert it into a single-family home?
Pretty much just the income. I purchased the home. I worked for it. I was hoping to, make it a little bit better. Contribute to the neighborhood. So it was pretty unfortunate on how it happened. But pretty much just that rental income and me just being a part of the community. It would just be me living there. So I felt pretty much safer with somebody on the side of me. So.
Okay, any other questions?
I have one more. You mentioned about the garages. What, are you amenable to an alternative to a closing garage, or are you fixed on the garage?
Kind of fixed. It was a carport on the left side. So, if I wasn't able to have the closed garages, at least the carports. It's not as close to the sidewalk. I know we are a pedestrian-friendly neighborhood, and it's not pretty much that close to the sidewalk. So I feel it's pretty much out of the way. And I have like 3-4 trees in front of my house. Like, if you're just riding past it, you really wouldn't notice.
Thank you.
And I would like to add, being a carport is not as secure as a garage, and she's a female that lives by herself. So that garage would be much more secure for her.
Quick question, doesn't matter much, I'm just curious. What's behind your house? Is it just an empty, is it a low area or something? It's just, I can see where it's kind of landlocked.
It's kind of like low. It is like that water. What do you call it? Like a ravine that's kind of down some.
Right.
And like to the right, that goes into like the backyard of my neighbors.
Gotcha. Okay. Any other questions?
I have a quick question.
Yeah, go for it.
I can have a question. Is there like anything against swimming pools in the neighborhood?
As long as there's space to put a pool in. Yeah, I mean, I think you gotta get a building permit when you do a pool, but like, there's nothing.
Upon discovering, it's like a pool that's like way back there. It's abandoned and everything. It's not being used for like years or whatever. But I was just wondering that.
Question, even if we were to.
Okay,
Even if we were to approve this, it would still have to go before landmarks.
That's true.
And so we're just allowing it to go before landmarks.
Correct. Okay, other questions? Okay, thank you all very much.
Thank you.
Thank you.
We're going to move to discussion, so if we could get a motion to approve BOA 2025-77 as conditioned by staff.
So moved. Second.
Let me ask the secretary something real quick. Now, with that motion that we just put forward, if we approved it, we would then be approving a garage unless we put a condition against the garage? Or do we need to handle these?
You could handle them as separate votes, but as you've currently done it, you didn't, it sounds like all three were motions.
Okay. Could we just do a condition? Or do we need to separate?
It would probably be better to separate.
Okay, so let's rescind that motion and let's first start with a motion to approve a variance to rebuild the existing duplex on BOA 2025-77. We'll discuss that.
Did we also want to include the circular driveway?
And the circular driveway. Thank you.
So moved.
Second.
Okay. All right, any discussion of those matters? So this is just the house.
It's just the house in the driveway?
Or duplex.
Duplex in the driveway. I have no major issue with it, simply because that is what it was at first. And if she purchased this with the intent of it being a duplex, the fact that it burned down is not changing what the intent is. Right. So I have no major issue with it becoming back a duplex.
Right. I agree. Any other thoughts on that one?
I agree too, but I do want to make sure I understand or make sure we discuss, the fact that the plans for that area, it sounds like they say that any new construction needs to be a single house, a single residence, and how are we? So we have two competing interests. I want to make sure we discuss it and think about how that comes into our analysis.
Can I just say, if this were a vacant lot and maybe a new construction development, I would be in agreement with trying to uphold the new development plan, the plan, long-term plan. But because this was existing, this was something that we were already looking at. Now she's bringing it back in probably newer form, but I think it's only fair to let it be the way it was. New development, vacant lot, yes, a single-family home. But she's, coming back to where she was. We're giving her status quo. Now, she tears it down again after this one, yeah, we would fight for more of a single-family home.
Or, if it was an investor coming in that just bought it after the fire, I'd be thinking possibly different as opposed to she was living there, had a fire, and now she's trying to just get back to where she was.
All right, thanks.
Yeah. Any other thoughts or questions on that one? All right, so, Mr. Secretary, if you'll give us a roll call vote on that motion.
Mr. Claybrook?
Yes.
Mr. Campbell?
Yes.
Mr. Bruce?
Yes.
Ms. Conrad?
Yes.
Mr. Love,
Yes.
Ms. Gerlach,
Yes.
Vice Chair Savage Selden.
Yes, I find that the standards of the UDC of 9.22.6 are being met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey.
Yes.
Motion carries.
Okay, so now let's get a motion to approve the third variance, which is from subsection 3.9.2H to allow two front-facing garages.
So moved.
Second. Okay, thoughts on that?
Now, that one is a little harder to fully approve simply because that is not something that was there at first. So this is introducing a new element that the code currently states is not acceptable. So for that matter, I don't feel strongly about this one. I feel like if some time was taken, maybe there is an option that the house can be reconfigured to allow for a straight drive but at this point, we're adding an element that was not part of the original. So that's a little harder to approve, especially given that we just approved the duplex as a variance. But that's just my personal.
Seems a bridge too far. I agree. I think that a couple things. One, you're just not supposed to, you're really not supposed to have them. They were actually I think Mr. Blanca's had the thing, if you do approve a duplex, you need to do these things. And one of the things you're supposed to do is make sure you pay attention to your garages and carports. I think we're doing that here, which is what we're told to do. Two, I honestly just think it's gonna be better if they can figure out a way to put the garage in the back. I think that's gonna be more secure. They can have a gate on their driveway if they want to. I think it's a better investment in the property to have one for the look of it, but two, for tenants. Take the time and figure out how to do it. Yeah, it's gonna be better.
And also just the aesthetics of two garages in that close proximity, that's a lot of your building frontage. And just from a aesthetic standpoint, I think that'll change a lot of the character.
Yeah. I mean, it'll cost more to do, but I think it'll be an increase in that property value by following the code on that. Other thoughts?
Yeah, just going through Google Maps and previously, the parking was in the rear previously, so that's in line with minimizing the change of the initial purchase.
I'm trying to see that lot width looks like the lot's probably about 70 feet wide. I think you could adjust that a little bit to get 12 to 13 feet on one side. I think it's possible. So, other thoughts? All right, Mr. Secretary, will you give us a roll call, please?
Mr. Campbell,
Are we voting in the affirmative?
We would vote, an affirmative vote would allow the garage.
Okay, yes. No.
Mr. Love,
No.
Ms. Conrad,
No.
Ms. Gerlach,
No.
Mr. Claybrook,
No.
Mr. Bruce,
No.
Vice Chair Savage Selden.
No, I find that the standards of the UDC of 9.22.6 will not be met and will be duly detrimental to the properties in the vicinity.
And Chair Rainey.
No.
Motion fails.
Okay, so you got approved for the duplex and for keeping your circle drive. We just got to figure out something, a different place for the garage. But best of luck to you. I'm sure it's going to be great when you're done. All right, if you'll call the next case for us, Mr. Secretary.
Item number 10, BOA 2025-86 at 644 and 646 Dickinson Street.
Okay. Is the applicant here for the Dickinson Street? Perfect. The applicant for Dickinson? Show of hands. Yellow shirt, okay. Thank you. And then I've got some opposition. So Ms. Abiosi, if you'll give us a staff report, please.
Good afternoon. I'm Trusa Buosi with DPD. I'm presenting on 646 Dickinson Street. It's also in the Valentine Evergreen Historic District. This is the location map. This is the zoning map. It is in the R6 district. The applicant is requesting for a variance from subsection 4.4.4a to allow a driveway that does not extend at least 20 feet beyond the front facade of the house, and also to allow a front yard parking part. So these are the side photos. This is how the property currently looks like. And the applicant is requesting for just one parking pad around the front part. This is the area the applicant is requesting for the parking pad. There were issues with the applicant's fence being in the green line easement, and the applicant worked with us to change the site plan to make sure they move. So part of the applicant's property is very unique compared to the area because of the green line next to it, and there was a 50-foot community easement, which makes it difficult for the applicant to provide parking at the back of the house, and the only option for them is a front yard parking pad, and if this is not approved, they can't provide any legal parking on the site of the property. So due to those reasons and the unique nature of the lot, staff recommends approval with conditions, with the condition that they provide landscape around the parking pad. Thank you.
Okay, thank you. Are there any questions for staff? Okay, if the applicant will come forward and give your name and address for the record. Mr. Applicant, are you? Opposition. Opposition. Is the applicant here? You, sir? Go ahead. Sorry, I missed you. I saw you stand up more than once, but I wasn't paying attention. Right.
My name's Douglas Nicholson. I represent Ms. Tonga Nguyen of Tonga Properties.
And you're her attorney, correct?
I am.
Okay, so I'm not going to swear you in. You're an officer of the court. So go ahead and share with us.
Okay. Mr. Chairman, ladies and gentlemen of the board, thank you for having us today. We're here to get a variance, hopefully, to get one parking place. I don't know if you are very aware of this property, but it's been compromised to some extent because the Green Line, which everybody loves and we want it to prosper as well, cuts across the back southeast corner of this property. And it ultimately creates a bit of a problem for parking. This is a duplex. So we have two families living there. What we're asking for today is not about convenience. We're asking for a variance because there is genuine hardship created by these circumstances. Because this property is uniquely shaped, and the Green Line, wonderful community asset that it is, impinges on that. The reality is we're not seeking anything other than this one parking spot. When you combine the required 50-foot setback from the street with the 50-foot Green Line easement on the side, there's literally nowhere on this property to legally park the four vehicles that serve the two-family duplex. The rear yard is inaccessible, and there are only 6 feet between the house corner and the property line. We don't want any money. We don't want any extra convenience. We just want to safely allow people to park at the place they live, not out on the street where things are a little more dangerous. In reference to that, my client, Ms. Nguyen, bought this property in December of 2024. She then attempted to upgrade it by replacing the crumbling, degraded asphalt driveway, and she wanted to put in a concrete driveway. She did that. She also put a small parking pad at the end of the driveway, at the head of the driveway. Then some folks came along and told her she couldn't do that. So we stopped all work. We investigated, wanted to come before this board, and in so doing, we did everything that needed to be done, which is started with getting a survey. Well, unfortunately, the survey showed that the fence that was not built by Ms. Nguyen in the backyard, it had been built decades ago. It infringes and encroaches on the Green Line easement. Additionally, the parking pad at the head of the driveway impinges and encroaches a bit, about 4 to 5 feet on the Green Line easement. That was done in April, and we have tried to do everything we can at this juncture to get before this board so that we can hopefully get a variance. We've got no other recourse but to seek a variance. This was not just an improvement, it was an essential safety upgrade. Concrete is stable. It's not like asphalt. It doesn't degrade quite as fast. There have been some objections to this from the community, one of which is they don't like the encroachments on the Green Line, nor do I. However, we have committed to relocating the fence so that the fence is not on the Green Line, not on the easement area. We are seeking, however, to maintain that small parking pad that's at the head of the driveway, and it does encroach a slight amount onto the Green Line easement. However, as you can see, there are several trees on the south side of the driveway that are also on the easement. None of that area is ever walked upon. The easement extends for 50 feet from side to side. The spot where the encroachment of the the concrete that was poured, is never walked upon by anyone on the easement. They walk on the general easement line. The concrete driveway and parking pad represent the minimum infrastructure necessary for the duplex to function safely. All we want to do is make sure that people are able to get in and out of their cars safely, get their children in and out of their cars without unloading everything on the street and walking it up to the residents. Some neighbors have suggested that the way to solve this is put lease restrictions on parking. Even with fewer cars, any parking in this location still violates the setback requirements. We don't want to do that. We want to get a limited variance of only one parking place at that spot. We're asking today actually serves the public good in multiple ways. We maintain an organized concrete parking area that moves vehicles off of Dickinson Street, and we improve safety from traffic and visibility for everyone, drivers, cyclists, pedestrians, everyone. We prevent the environmental damage that happens when people park on grass areas, causing unsightly brown patches and erosion. This concrete infrastructure supports property values and neighborhood stability. Everything about this situation meets the legal standard required. The unusual characteristics, that unique combination of the Green Line easement and lot dimensions were not created by my client, but exist due to permanent public infrastructure that has constrained this property for decades. The hardship is real and undeniable. Without this variance, this duplex simply cannot function as a safe, modern housing for two families. The variance serves the public welfare by improving safety and preventing environmental degradation. It's completely in harmony with the Development Code's goals of providing adequate off-street parking. In conclusion, this is exactly the kind of situation that the variances were designed for. They're asking for a minimum relief necessary to operate a duplex safely and responsibly in a location where extraordinary constraints make normal compliance impossible. We respectfully urge you to approve this variance. The existing concrete parking pad as it sits is the right thing to do for the people who live there and for the neighborhood. We are asking for your consideration. Thank you very much.
Thank you much, sir. Are there any questions for the applicant?
I have one question. So this is for one parking spot to be added, parking pad. Where are the other cars? Are they gonna remain parking on the?
There is some parking at the head of the driveway, and there would be additional parking in that pad that was added on the south side of the driveway, right at the head of it. And I believe we are asking for one additional parking place outside of the 50-foot setback from the street, but also along the south side of the driveway.
Okay, could you pull up the site plan for us, please, ma'am? So what we're really talking about is this area that says proposed one-car parking pad in the corner of the triangle, correct?
I believe so.
Right there.
Right there, yes.
Yeah. Because the other area at the head of the driveway, there's some concrete going into the easement.
Yes, there is, Your Honor. I'm sorry, I'm used to being in court.
I'll take it. Like, we can't really talk to that because that's not our property to give a variance on. So all we really have any control over is just that side one, correct? Yeah.
Yes.
And that's where we hope the one parking spot can be. We have moved away from parking in the front of the house. We cannot park. You see the access to the backyard is so limited, you can't get back there.
Right.
And who wants to pour a parking pad back there where their children play?
Yeah. Okay.
So we are seeking only that one parking place in the area that you highlighted, Mr. Chairman.
Okay. All right. Any other questions? All right. What we're going to do is we're going to move to the opposition. Then you'll get, 2 minutes? 2 minutes for rebuttal. Okay. Thank you very much.
Thank you.
All right. So, Mr. Baucus, do you want to be first up again?
Yes, sir.
Okay. And then, yeah, you're already sworn in. We'll consider you sworn in from the last one. Yeah.
Brian Bacchus, Bacchus Urban Design Group, 5320 White Diamond Street, Memphis, Tennessee. I stand in opposition to this case on behalf of the VECA Voluntown Evergreen Community Association and the Historic District. This is for the 644, 646 Dickinson Street in that area. Next slide, please. Again, this is a land use map for that area. You see the site, the lower left. This is the generalized land use map that at once currently is a duplex. Next slide, please. And again, the future land use is, again, single family. Next slide, please. So neighborhood assessment, also dealing with the parking problems and the traffic congestion in the area that is for increased activity for duplexes. It's changed the character of the neighborhood, designed for single-family use. General planning recommendations, long-term program to convert duplexes into single-family. Again, we're harping on the fact that this plan was approved and these recommendations should be taken into light in accordance with that comprehensive plan. Next slide, please. This is a view of the site. Again, these photos were taken yesterday. This is a duplex, upper left, two-story unit, and lower left is a view from the pedestrian way from along Tutwiler. The upper right is a view from the drive where the applicant is proposing the front parking pad. As you can see, there's a stake to the right of the site plan that indicates, to the side of the photo that indicates the property line, as well as the lower right where the cars are parked to the gate. Next slide, please. Access management is the issue here. Residential driveways, the width of driveways may be no wider than 16 feet at the right of way, at least extend 20 feet beyond the front facade of the home. In instances where the drive leads to a detached garage or a carport where there is no garage or carport. If the variance is allowed for driveway site improvements, any new private drive and parking shall comply with the zoning code for garage and carport placement, access management, and location and number of required spaces. Next slide, please. So the use variance findings of fact, subject property reveals unusual characteristics as stated by the attorney, and it does exhibit an exceptional physical features as compared to other properties in the R6 historic district zoning. Practical difficulty, there is an unusual characteristics found to apply above, and the strict application of the zoning code results in a peculiar and exceptional practical difficulty. So the variance meets those requirements. However, a two-family residential non-conforming land use in R6 historic district zoning is not practical due to the limitations on required parking and site improvements. Next slide. So in conclusion, the VECA recommendations as stated before you, and if a variance is approved, we recommend that the parking pads comply with the UDC. And any single-family residential use is a more practical application for site improvements for parking, which prolongs a non-conforming land use for a two-family duplex dwelling unit. In essence, it prolongs the use of this property. If you approve a variance for parking in the front yard, it prolongs the use of this property for a duplex. Any new site improvements shall comply with the UDC because the site plan submitted should illustrate more details for the board to consider before it taking any action. Mr. Chairman, members of the board, that's the end of my presentation, and I hope you consider this recommendation.
Okay, thank you, Mr. Bacchus. Is there any question for Mr. Bacchus?
I just got a general question. If this was, for some reason, a single-family home, will we not still have the same issue of front yard parking?
I think you would. It's that you would probably possibly have less people in one house as opposed to two, so you might not need as much parking.
Well, I was just trying to find how to get multiple spots. Just
Yeah. I think we'd be in the same boat.
okay.
Yeah. Yes, sir.
Can I respond?
No, sure you can.
Yeah, the single-family home, the parking would be less. The requirements would be less.
Depending on the size of the family. I mean,
Correction. Depends on the number of bedrooms.
right. I mean, my house, 5 cars, you know, it's more than, and it's a 4-bedroom house.
Right.
So, but, you know, what's better, having them park on the yard or I mean, I don't know that you're going to eliminate that situation.
Yeah.
So it's going to be prolonged without, I don't know. It's a difficult.
It is.
It's
Yeah.
a very difficult thing.
All right, Mr. Cordova, if you'll give your name and address for the record, please.
Oscar Cordova, 700 Dickinson Street.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead and share with us.
I don't have much of a presentation, but I feel what they're going through is what most of us in that neighborhood go through. We don't have much driveway space. If you look up and down that street every day, people are parked on the street with no issues. It's a very quiet street. At night, that house actually can use all of Tutwiler for parking. The issue with that house since they moved in is they've stored unused cars with no tags. If you go there by nighttime, 6 to 8 cars are stuffed on the grass in the street, flat tires, car parts on the hoods. It's been a mess since they moved in. It's been just stored cars with no plates. It's just been a junkyard since they moved in. I think adding more space is just gonna have them store more cars, as they've been doing to our neighborhood. I'm sure the owner, when she bought the house, she would have known about the size of the property and the restrictions they have, but everyone in Midtown has the same issues. Most homes have 3 to 4 cars. We have duplexes right down the street, and they don't have issues pulling in and out of the driveway and parking in front of the house. And I think we should keep it that way. They should have a little more respect of not parking on the grass. And when they invite people over, the whole front yard is full. They park on the sidewalk. They're just trying to use up as much space as they can and not think of the people in the neighborhood. And that's all I have.
Okay, thank you, Mr. Cordova. Any questions for Mr. Cordova? All right, thank you. Is there anybody else here to speak in opposition? Come on down. Yes, sorry. That's okay, thank you. All right, we have 3 minutes left if you want to give your name and address for the record.
Natasha Strong, 1680 Jackson Avenue.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, go ahead, Ms. Strong.
Although a note on the site plan says the fence will be relocated to the property line of the subject property, the newly added parking pad is also on the V&E Green Line property and we strongly request that it be relocated so that it is on Dickerson property. The concern is encroachment. So even if this is approved, it is encroaching on the V&E Green Line property. And as was pointed out by the neighbor and Mr. Bacchus, there is opportunity to park in the back, the V&E Green Line. If you were willing to, if they take the parking pad to the back rear yard, that is the preference for the V&E Green Line. And we know that it is an encroachment with the fence and everything, but the preference is to have it towards the back. And if the application is approved, there should be a condition that the fence and paid parking used by the duplex be removed from the V&E Green Line. And if they just take it further back, that is the case.
We can't improve that because like they don't own the property to get into the back. It's the actual line is too close to the
What I'm
house.
saying is, as representative of the V&E Green Line, the preference for the V&E Green Line is the parking pad, driveway, not the parking pad that's installed, the driveway to go back.
Okay.
So,
I'm not trying to confuse you.
now, are you saying that you would take the parking pad to the back of the house, correct?
They take it to the back of the house. We understand because of the easement with the V&E Green Line. We understand right now what they have is on V&E Green Line property. The parking pad that's installed and the fence is on the V&E Green Line property, correct?
Correct.
Right? And because of the 50-foot easement, because this is the V&E Green Line, right?
Correct.
They're saying they have no space. What they have now is on V&E Green Line property.
Right.
However, remove the expanded parking pad that they've installed without a permit. Remove that from the front. The driveway they have, because they can park 2 cars in the driveway because they already do it now. Expand the driveway further back.
I think the question is, can we approve encroaching more past the Green Line's property line? And I think the answer is we couldn't approve
Towards the
more
front.
encroachment to that.
The encroachment in the back behind the fence. If you can go back to the, you see the 2 cars right there in the driveway? That's an existing driveway. You see 2 cars parked there, right? Now, right? You see the fence? It's fenced in. So if you expand the driveway further back, it gives them more driveway space because it's behind the fence.
Right, but the fence already has to be moved because it's not in the right spot.
The fence is already on the V&E Green Line property.
And it's being moved because it's encroaching.
It has to be removed.
So they have to move the fence in, which only 6 feet between the fence and the house, and you can't get a car to the back in that little space. Like what you see there doesn't represent what they own. It's over fenced.
Right.
So we can't approve them putting a driveway over property that they don't own. Even though it makes sense to y'all as B&E, like, hey, we'd rather just use a little bit to go back there. That can't be something we can't. That's not something I can do. Y'all might could come up with some legal way of doing it, but that's not in our purview.
Yeah, you have to get like some legal modification of the property line.
But you can continue. Go ahead.
Yeah, the driveway couldn't go through the whole fence. The driveway would have to go through only 6 feet of the fence.
What
Could
I'm
not
saying-
use that whole fence width.
So let me, I'm looking at it. The parking pad that was installed, the request from the Vianney Green Line is that it be removed. The extended or expanded parking pad be removed because it is on the Vianney Green Line easement and it's in the front of the property.
Okay.
Sorry.
Mr. Chairman, I have a question. Ms. Strong, so are you representing Valentine and Evergreen Community Corp?
The Vianney Green Line.
The owner of
yes,
the Green
yes.
Line.
The Green Line.
So I think, if I'm,
But anyway.
correct me if I'm wrong, they're basically saying they're willing to grant an easement onto their property for the driveway, basically to just go back so they can go into the backyard. Basically, there'd be no front yard parking pad. Is that the easement that y'all are you willing to do that? Because that's what the board's trying to say. Unless you were to grant an easement to go into the backyard on the Valentine Evergreen Community Corp's property, it would be physically impossible for a car to drive into the backyard.
Give me a moment. I'm looking at. They're saying, okay. Thank you for your patience.
No problem.
The application for retroactive approval of the parking pad code is not properly submitted because it does not. Well, anyway, it does not include the signature of VECO, the Vianney Green Line. Okay. The application before the Board of Adjustment is not proper because VECO has not signed the application. The labeling of this property as an easement is not correct. The Vianney Green Line property is not a transportation easement like a public street or alley. It is owned and maintained by the Vianney Green Line.
Okay, so in response to that, I think to be clear, the board is not considering any of the developments that are on the Valentine Evergreens easement.
Okay.
They're only considering.
I'm just relaying. Thank you for. I'm relaying for someone who's not here today. I'm listening.
Yeah, no problem.
Let's see. And the other concern they have is that this approval of this would continue current unsightly conditions of all vehicles owned by both sides of the duplex being stored in the front yard on one side of the property immediately adjacent to the Vianney Green Line. And they're also concerned, as you saw, about the trash bins from both sides of the duplex forever sitting immediately next to the Vianney Green Line, which is a pedestrian trail. Okay. That's it. Thank you.
Any other questions? All right. Thank you, Ms. Strong. We appreciate it. So I'm looking at like the tax map and stuff. And my question is, I always just assume like the other green line that there's an easement for the green line that goes through East Memphis. There's an easement from the railway to use that. Do we know, are there any reverter rights for the L&N or the old Ohio that used to own that, or is it really owned by the question?
One that I do not have the answer to.
Yeah. Okay. Because, I mean, if I knew it could happen, I would rather them work out a way to get a little easement over that area to do the parking in the back instead of us doing front yard parking, because we don't like front yard parking, but also don't know that that's possible.
If the applicant was agreeable, we could have a 1 month hold for them to look into that.
Yeah. I think we're done with the opposition. It's Nicholas, correct? Mr. Nicholas? Nicholson, I'm sorry. So what we're talking, do you know who owns the Green Line? Have you done title work on that to know
I do
what
not.
rights they have?
I do not have that.
Because like we would much rather them allow y'all to have your fence a little bit over to get, I know you don't want to put it in the back, but that's where we would want parking if we could do it. And we're wondering if we could do a hold to take a month to figure out if that's even a possibility to do.
Well, Your Honor, I mean, again.
I'll take it.
I want to make you a judge. I really do. This variance is not going to cause any more problems. It's the solution to the problems.
Well, I think a better solution is having all the cars in the back and off the front where they can do that. That's what code would tell us to do in this situation. We didn't have the property to do it unless they're willing to give us an easement.
Exactly, and that's what I see as the problem. There's only a 6-foot area that you could even squeeze through there.
Right.
However, let me make a couple other quick points.
Yeah.
All the pictures that we saw, those are all before Ms. Tongan Nguyen bought that property. She has done everything she can to straighten it up and not have people illegally parking out on the lawn, anything like that. Secondly, I would tell you that with the chairman's approval and the board's approval, I have a speaker here who would like to speak in favor of this. That's Mr. Melvin Burgess, the property assessor.
Yeah, I mean, we have like 2 minutes left for rebuttal.
Okay.
We've been answering questions now, so if Mr. Burgess would like to come talk to us. How you doing, Chairman? I am going to swear you in, if that's okay.
Oh, that's fine.
If you'll give your name and address to the record, Mr. Burgess.
Yeah, I'm Melvin Burgess, 363 North Avalon.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, thank you.
Yeah, so I'm here not on my job capacity, well, kind of, because I know when Ms. Newton came to me as the assessor, there was some questions that she was asking about the property, and that property that she is trying to improve, it is on her property. I'm coming as her neighbor up the street. You know, we were all part of that Midtown development where the highway was going to go through. Built our homes in the 90s, and of course, we were up under the great leadership of Cindy Buchanan, who was on the Landmarks Commission at that time, to tell us what we had to do, how we do it, and what was part of the city's plan. And one thing that that comes up that probably was not in the conversation when we were talking with her was we did not know when we built our homes over in Midtown that we had to we had to pay for our own driveway and come up with our own sidewalk. So what I'm saying here today is Ms. Newman, she didn't know. And we know everything has to go before the Landmarks Commission, as it pertains to the approval process. So, she was not made aware of that. And to all due respects, other Landmarks Commission, you have to follow the rules. And we do know that. It's like you can't cut down trees over there in that area. But I know as the assessor that any improvements which she has done with her company over in Midtown and over in Central Gardens have always added value to our neighborhood over in Midtown. So I think, it's an oversight, and I know the guidelines will be followed in the future because now she knows. But just to respect to her, all due respect to her, she did come to my office, the assessor, to find out how this process worked, and she just didn't know. So I'm just coming on her behalf, and the great job that she does, and improvements does add value to some of the homeowners who don't know that to your property. It brings value add to it. So I'm just coming on behalf of her, and thank y'all for the time, and thank y'all. See you, Bruce.
Okay. Any questions? Okay, Mr. Nicholson, do you want to add anything to that? Okay. All right, thank you very much. Okay, at this time, what we're going to do is we're going to get a motion to approve BOA 2025-86 as conditioned by staff.
So moved.
Second.
All right, any discussion?
One item, now realizing this needs to go to landmarks, we're missing our standard condition. So if I can read it and you would like to amend the motion to accept it.
Please.
Should no certificate of appropriateness be approved by the Memphis Landmarks Commission by February 27th, 2026, this variance shall be rendered null and void. And that would be a new condition number 3.
Okay.
Without objection.
No objection, that will be added to the motion.
No objection.
Okay. Other thoughts?
I have a few, Mr. Chairman.
Yeah, go ahead, Mr. Love.
Thank you. We've repeatedly had cases like this come before us, cases where there is a multifamily property that's situated within a residential district. I think that one of the things that we have to look at is that this is a signal from the market. We know that right now that Memphis needs another 30,000 units of affordable housing. I think the Unified Development Code, or the Memphis 3.0, excuse me, supports what's called a missing middle, and that is for properties just like this, duplexes, quadplexes, and lower density residential land uses. And I think that it happens best when it's peppered throughout a community and not concentrated in one area. I think that in that case, it makes neighborhoods a bit more versatile. And I think that mix of uses adds to the value of the community. And all of the time, it's not going to be perfect. I think it happens best when it's as intended. I mean, this duplex was built by right at the time, and I think supports where we're going as a city, particularly with our plan in the Memphis 3.0. The Valentine Evergreen plan was done in 1997, and the rezoning, as we talked about today, was to downzone it to residential. But I think the direction that we're going and the demand of affordable housing would justify a second look at that. And I think in cases where it's done well and where situations or properties like this duplex are allowed to continue, I think adds to the direction that we're going as a city. So I intend to support the application. It's not perfect. Like we said, if we could, we would say park the cars in the back. But working with what we have, I think that having one parking pad added to this property, I think would be a better solution. Cars spilling out into the right-of-way adds more vehicular clutter and a safety issue. If people are trying to use the property to its full utility, I would think that residents having groceries and kids and all that would be better suited to park at the house. So I intend to support it. It's not perfect, but I think that it's a small concession to allow this duplex to continue to function. I do have one question that I'd like to ask of staff or anybody else that could comment on this. It sounded like there may be a possibility of the people that own the Green Line to allow for the encroachment so that they could go to the back. Is that open? Is that something that can be considered? I don't know if we.
So we were talking about open.
Oh, okay. That's the best way to go there.
In my quick and dirty research I did, it looks like back in, when was it? 1996, the railroad just quit claim easement like they did on the other Green Line, where they actually can come and take that back if they want to. I think they gave up their rights in that area. You know, this goes into that. I was looking at the map. It basically dead ends into Crosstown, and then it goes all the way out, and then they start reusing the rail again there, kind of near Chelsea, and there's that little rail yard you see, like kind of it's just south of Chelsea, closer over to. I'm trying to think of what the street was, but further west. You know, on the other side of Hollywood, even. So I don't know when they would want to really. It makes sense they gave it all the way up, because it's not like it's connecting anything. It dead ends to a place that doesn't need rail. So I think that somebody local owns that, not the railroad. If it was the railroad, I would be like, nah, there's no chance.
Yeah, it's tough to work for railroad. Well, I mean, yeah, I think that if there was a potential to take the cars to the backyard, that would be ideal. But the point I wanted to make is that, you know, we've had a couple of cases like this, and I think they're going to increase. And it's tough to make a decision on a lot of these. I mean, I understand the point of Becca. I understand them wanting to protect the character of their neighborhood. But we have a incredible demand, not only in Memphis, but across the United States, as housing continues to rise, housing costs continue to rise. And although this may not be perfect, I think it's reasonable for this property. Thank you.
Okay. So, other thoughts? Is anybody more in favor of a hold than hearing it today, or than deciding today? Sorry.
I think I'm back with the hold. I mean, if we can get a better understanding of ownership and providing some type of, you know, easement, that gets us all back to what the code requires, you know, get what seems to appear to some sense of assisting in the parking, but at the same time, keeping with the aesthetics of the neighborhood. So, and safety. I think that was a big concern. So I think a hold and just kind of negotiating out this easement would be pretty, I'm thinking, fair. But that's just me.
Well, I think a hold would be best. However, there are a couple of problems with that. One, we don't know who to talk to represent the Green Line, and we don't know if they'll be willing to even talk or negotiate, you know, to discuss giving up an easement. Number two, when the question was asked to the applicant, sounded like they weren't really willing to have that conversation. So we can't. So yeah, if they would talk and come up with an easement, I think that would be best for everybody. But we can't make either one of them talk. I don't know if we, you know, we don't know if they will talk, and we certainly can't make them. Which leaves me to, even though, you know, them talking and working something out would be best, it kind of leaves me thinking that, well, we can't make that happen, so I think we have to make a decision today.
I think that would give me. I think that I would probably hear some evidence of who was and wasn't talking about it next month. So if there's no viable way for there to be an easement, or if somebody from Becca comes in and says, no, listen, we talked to them about an easement, we were willing to give 15 feet, here's who the owner is, and they didn't want it, then that makes me think something different. But I think I could get some testimony to make me know who was trying to talk and who wasn't. But I do hear what you're saying. So I think I am in favor of hold.
I'm in favor of a hold as well, but if they insist on a vote, I'm gonna vote with the information that I have at this moment, which might not be in the best interest.
Yeah.
But I would prefer a hold.
Because I want to hold, I will vote. I think I would vote no without a hold.
Yeah,
yeah. We're through with testimony.
I'm sorry?
We're just in discussion. We can't have testimony right now.
I was just getting interject.
Yeah, no, thank you. If unless we have 5 people that want to hear what they have to say, and then we'll open it up to the other side as well.
So how does a hold, can we make them hold, or do they have to agree to hold?
We can absolutely hold.
We can make them hold for, okay, that's right.
1 month. 1 month.
With the agreement, we could go up to 3 months. Okay, that's right, okay.
And do we have 5 got people that want to hear any more testimony at this point? Okay. All right, so we would like to, can somebody make a move for the hold?
So move.
Second.
All right, all those in favor of hold signify by saying aye.
Aye.
Any opposed? None. So, we'll see y'all next month. We have two competing interests here that'll tell their side of the story of how it goes, and then we'll decide. Next month. Yes, sir. All right, thank y'all very much. All right, Mr. Secretary, if we could hear the next case, please, or call the next case.
Item number 12, BOA 2025-88 at 4634 Normandy Avenue.
Okay. All right, is the applicant here? On Normandy, is there any opposition here? Yeah, we do have opposition right here. Okay. All right, if you can give us a staff report, please.
I will be giving a presentation from the staff report as a presentation was not prepared in the anticipation of item being pulled off of consent. Give me one moment here. As mentioned, this is a presentation on BOA 2025-008 located at 4634 Normandy Avenue. This is a request to allow 14-foot setback encroachment in the rear yard where the setback requirement is 20 feet. This property is located in the residential single-family 10. The applicant is proposing to develop more or less 248 square foot addition that would encroach into the rear setback by 14 feet. The addition would be located in the northwest corner of the subject property. The addition they're proposing is an ADA compliant addition to house and be able to have better care and accessibility to their loved ones. I'm going to scroll past to kind of give a little more background into the configuration of the lot. If you all look here at the aerial, the lot has much more width than it does depth. And so the applicant is proposing the addition here in this location. And I will scroll past a little bit more. And this is an aerial view. And so the addition would be in this general area here, and it would be attached. Here is a site plan of the proposed addition here. As you all can note, what you saw in the aerial, which I'm gonna scroll back up here, I'm gonna go a little back and forth here. In the aerial, there is this additional roof that you all see. This is the existing porch that was there when the property owners purchased the home. They just simply put a roof over it. Over time, they did not build this new. It was already there. I will also say this property was built with existing encroachments. And so when the opposition comes up to give their report, a lot of their concerns are with things that were existing, in which the applicants and the property owners just went along with what was there, made the additions to, which is the roof, for instance. And so going back to the proposed addition here, this is simply what it would look like. There is also a ramp being proposed, but it also will be in line with the driveway. And as you can see here are the encroachment notes. The building setback is here, and as you all can tell, it does encroach beyond the building setback line. I'm going to fast forward to the opposition because the opposition did submit photos, and they are found also as well in the staff report to better kind of alleviate or allude to give the visual to what I was speaking of with the existing structures and premises. So the porch or this area was already here. They just simply didn't even enclose it, but they just put a covering over it. And then there's the retaining wall situation and the fencing. This retaining wall was already there. This was nothing that the property owner built. This is already pre-existing. And so all of these things were already pre-existing. They were already there. And if in today's code, if this was built, it would be in violation of the code. And that concludes my presentation.
Okay, are there any questions for staff?
Are there any, in the pre-existing non-conforming matters, are there any, will there be any additions or upgrades to that in this particular?
No, nothing of that is included in this proposal. This proposal is only strictly for the encroachment of the proposed addition, which you all can see here. And as mentioned, the measurements to which the encroachment, which it meets the side yard setback requirement, it just doesn't meet the rear. But as you all can see at the configuration of the lot, it has a pretty far setback from the public right-of-way, and as well as there's not much area to relocate.
Correct, thank you.
So, question, as far as the porch in the back, the covered porch, is that going away?
No, all of that stuff is existing. I just don't think
wow.
it was included on the staff report, on the site plan.
Okay, that's a lot of stuff. Okay, if the applicant will come forward, and if you'll give your name and address for the record.
Absolutely. Ryan Morris, AIA, 4870 North Terracestone Drive, Olive Branch, representing John and Tiffany Hurd.
Okay, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead, sir.
It's not made for tall people, that's okay. We documented a few of the hardships on the existing site. As it was noted, this site happens to be, and I'm going to paraphrase here, so this is the knowledge as best as I know it, approximately 200 feet wide by 100 foot deep is the general layout of the lots in this area. This one happens to be 200 by 100. All the other ones are 200 foot deep by 100 foot wide. You can see on that one right there. So this is one of the only properties that has a shallow backyard where everyone else would be permitted by right to add into their backyard. And the houses to the south actually do have 5 foot setback requirements there. It just happens to be that this side of the street has a 20-foot setback. So we are applying for the variance that we are following in context with the neighborhood, whereas all the other houses are approximate here, approaching that 3,000 square foot on the ground floor. This addition would be putting that in character with the neighborhood and then not making the house any wider, which would be an anomaly on the site, and going into the north-south direction, which would follow the character of the neighborhood as well. So that the hardships, one is the site constraints, and then also the house addition will be for Mr. William Hurd here and his aging mother, so trying to be accessible. So the entire space will have larger door frames, bathrooms with turnaround radiuses and all of those. So he'll be using the existing driveway on the left side of the aerial there, and they would be permitted by right to put the building on the right side of the lot, but that would increase more hardships on how to access the site and be able to transfer from the parking lot to the house. Then there's also the fact that the existing residence is a a multi-level house. So all the program on the left side of the house would be your dining room, your kitchen, your shared amenity spaces would be open to William, and that's the area that we're trying to connect to with the house addition back there. So we meet the side setback requirements, we meet the front setback. It's just asking for the variance to be reduced and trying to be mindful that 5 foot would be all the way back. So asking for a slight alleviance there and only going 14 foot instead of the entire way back. In my opinion, it's a very modest addition. Two bedrooms and 2 bathrooms and a living room space is going in here in that approximate 50 by 20 foot space.
I'm still looking at plats and stuff, sorry. Got a question of staff, maybe. I'm trying to figure, did this lot used to be a lot deeper? Is this part of a lot? It doesn't seem to match the plat. Let's see, lot 2.
You have to swear.
Sorry. Yeah, you want to go ahead and give your name and address for the record?
John Hurd, 4634 Normandy Avenue.
Okay, do you swear to tell the truth, the whole truth, and the true self you got?
I do.
Okay, go ahead.
From the research that we've done, this is a 2-lot subdivision.
Okay.
So I'm not sure what it was previously or when it was subdivided, but yes, it does seem to be a subdivision of some nature back in the 50s.
Well, now, so was the subdivision including the lot to the west, I'm guessing?
Looks like it.
Okay.
I believe the lot is not on the street. The second lot that is.
Sorry, I'm just looking up the pictures real quick. You have a question? Yeah, go ahead.
Yeah, I know we've had some accessory dwelling unit questions in the past. What makes this not an accessory dwelling structure? Oh, that's considered attached, okay.
Into the principal structure.
Okay.
And they're sharing common space, like the kitchen, and I mean, didn't you mention that, sir?
That's correct. So they'll be making a connection to the laundry room area. So the kitchen, laundry room, a dining room, and all that is shared space. They have a modest living room space to themselves inside the addition there.
And where are we getting the 20-foot rear line from? I got the plat pulled up finally, but it only, I see the 40-foot front, but I don't see the 20-foot back on there.
So the way I understand it with my surveyor is the rear and side setbacks are not shown in the 2-lot subdivision plat. If they are not shown, the current UDC code's required, and that's a 20-foot setback.
Okay.
That is correct.
Okay, all right. Good job. Okay, any other questions? Okay, what we'll do is we'll move to the opposition, and then y'all can come back and rebut. How much time do we have? You'll have 6 plus 2, so you'll have 8 minutes. So we're gonna move to the opposition. Are you Ms. King?
I am Ms. King.
Well, come on down and see us. If you'll give your name and address for the record, too.
Catherine King. I am at 120 North Perkins. I own the large property to the north.
Okay.
I've been there since 1993. I'm a lawyer, but I'll be happy to take an oath.
But you're representing yourself here, so I'm
I
gonna
am. I'll take it.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I will do that.
Okay, go ahead. Thank you, Ms. King.
Let me just say that these properties in this area are incredibly unusual. I am on actually the second layer down of a very steep hill. If you've ever driven from Walnut Grove to Summer, you know that right past St. Mary's School, there's a huge drop down that goes up. Their property is in the bottom part of that drop down. Mine is 3/4 of the way up the hill, and it's a very, very steep incline that is not shown on any of these diagrams. In fact, Mr. Hecht, who is also here, grew up on this property. This was Mr. Fuller Perkins subdivision. This was Mr. Fuller's farm long ago. And if anybody knows anything about it, it's Mr. Hecht. But this property slopes down from this hill, way down on Normandy. And it is a nightmare when it rains. It looks like Niagara Falls. If I grew 8 inches, I would be able to span the top of the fence to where they want to put in this on the side of my property. If you look at the diagram that they showed, if they take away that, just that building that's got the metal roof on it, there's plenty of room to take a car around there or whatever and have parking back there and also move that addition back there and not even get into the issue of a variance. The neighbors to the west, that is the original house that has been there. I remember it from high school. I think I went out with that guy. Anyway, it's been there forever. And Mr. Stegall, who had that property that they bought, erected this huge concrete fence that basically dams up all of the water that is trying to flow down, and it goes straight down, actually, it goes straight down my neighbor's driveway and the other people's driveway. It comes down, see the easement to the right? Mm-hmm. That's where it comes down. But there's plenty of space over in that area, and I'm sure, I don't know this architect, but I'm sure that any architect would be able to eliminate that metal building and add an addition over there for the disabled brother and the mother. And actually, I bet I'm older than his mother. But I will say, there is a huge discrepancy. I recently sold the very back portion of my property to Mr. Hatt, it was his childhood farm, and he's for decades wanted to buy that. He had a survey done, and it shows a property line that competes with the survey that the applicant has presented. So I know this group wants to not create problems and solve problems, and we've just got to get a handle on what survey is correct to tell you exactly where they're requesting a variance, because it could be more than you think or less than you think. I honestly think it's more, but I don't know. I'm not a surveyor. But we do have those 2 competing surveys. It's a dangerous location for anybody that's disabled, because if you look at the tree at the top of that white vehicle that's up on the top of the left side, it's almost like a ski jump. It goes straight down into Barfield. And Barfield is a heavily trafficked area with all the schools that are around us. We have St. Mary's, St. Agnes, St. Dominic, Concord Academy, White Station Elementary, all around here. So it's a very, very highly trafficked, populated area. And that house is unusual in our neighborhood. It is just not like any of the other ones. I mean, I think we all agree on that. It doesn't have what the other houses have. So it would be an anomaly. It would probably be like a 0 lot line, which this is not the neighborhood of 0 lot lines. And there was no site inspection done, which I had requested. I actually prepared packets for everybody because I don't know how to do a PowerPoint. But I have packets with correspondence, pictures that I have taken. There have been numerous opposition letters sent to the coordinator that were not part of this packet. And I think that's something that everybody needs to hear about, because this is an extreme request for a variance. Like I said, if I grew a couple of inches, I could span it. And it's right by my driveway. And that is where there is a huge storm drain that drains unless there's a flood, and then it floods over. So it's really bad.
Can you hand the packets over here so he can disseminate them?
Oh, and let me just say this. A lot of people did not know about this hearing, and that they had an opportunity to be heard, because the original notice was sent out, I received it on a Saturday. It said you had to reply by Monday at 8 a.m. And it says Wednesday, August 10th. August 10th was a Monday. And I've just stuck mine on top of the first one.
Okay.
But we'd like to solve these problems. We'd like to be a copacetic neighborhood, and we just don't want to make problems that don't exist or shouldn't exist. Did you want the copy with my notice of hearing on it?
We have copies of that.
Oh, okay.
Yeah. Are there any questions for Ms. King while we're getting this information?
I had a question regarding the competing survey. On your survey, what was or was there a difference in the yard setback in what you had versus what?
Yes, actually, I did not have the survey done. Mr. Heck, who is here, had the survey done when he purchased my property. And it was part of the closing and the part of everything that's in with the, who does the county trustee?
The assessor.
The assessor has it.
Mr. Chairman, I would just like to specify that, at least for competing surveys, we are not the jurisdiction to rule on that.
Sure.
But there is a question.
All right. Any other questions?
And like I said, none of us are opposed to having your parents or your disabled sibling. I've had both. I understand it all. Unfortunately, it doesn't get better, I must say, but making it easier for them there's not even enough room to park cars where they want to do it. Just saying.
I have a question.
Go ahead.
I mean, you mentioned, putting it where the metal roof was put on that covered patio. That's still the same encroachment.
Actually, I don't think it is, because on the survey that Mr. Heck had done, their concrete fence is not on their property line. See that concrete fence? That is not their property line. There is a brick retaining wall on the other side of that concrete wall that was there when I first moved in there in 1993. And that wall crumbled, and Mr. Stegall did not replace it. But he put up the concrete fence, and he put the concrete fence on the north side in front of the retaining wall. And on the left side that you're looking at with the cars, he put it on the opposite side of the retaining wall. And on Mr. Heck's survey, it shows that that retaining wall, the concrete one, was put on the next door neighbor's property. And there's some question about that. And that has come up with these surveys.
Okay.
Oh, and additionally, behind the retaining wall, in some areas, because that retaining wall runs straight, and these property lines in this area, it's old, follow the topography. So it actually follows the line of the hill. And, is that me?
That's you.
Oh.
Finish up.
It follows the topography of the hill, so there's more feet behind that metal building than what you can see, and over to the right that are their property.
Gotcha. Okay. All right. Any other questions for Ms. King? Thank you so much.
Thank you.
Appreciate you coming down. Okay, we have some rebuttal time. Because, yeah, that's all. That was the 10 minutes.
Oh, no.
Yeah. All right, so we have rebuttal. And I would have stopped you, but I had one card, so I didn't know you actually wanted to talk. So sometimes I'll give you a 2-minute warning. So we have 8 minutes if you need it.
That's fair. The survey that Mr. Hurd just got does show the property line on the other side of the concrete fence. I agree with Rebecca that there's still nowhere to build in that back portion of the rear lot there. Even if it's off some foot or amount there, it doesn't appear to be a wildly incorrect survey that we're looking at, and we can pull up the GIS and see what the dimensions are to cross-reference it as well. And yes, we did study, this is more just for me being an architect, we did study the house on the right side again. It is not in character with the balance of the neighborhood if we were going to be a 200-foot wide house when everything else is in the 50-foot nature. So trying to kind of tuck that in and be respectful to the neighborhood as well.
Okay. Any other questions for the applicant? I'm looking at a lot of maps.
Is there a plan of this already established?
Yes, not submitted. If you want me to describe it to you, that's probably not the most useful, but bedroom and bathroom on one left-hand side, bedroom, bathroom on the right-hand side, and then shared common space in the middle.
Well, I asked that just to ask, that space that resides between the old and the new addition,
Yes, sir.
what is that currently? Is that
Electrical panels and HVAC is coming into that nook right there, so we're holding the building off the backside of the property.
okay?
All right, any other thoughts, questions? Okay. All right, thank you all very much.
Thank you.
If we could get a motion to approve BOA 2025-88 as conditioned by staff?
So moved.
Second. Okay. Discussion?
So the 20-foot setback was kind of,
That's what code says.
it's just kind of, it's established by code, but it's not anywhere in the plan.
That's just, yeah, that's just zoning. That's zoning. Yeah, that's zoning. I mean, the other thing I'm thinking about is when I'm looking at that picture right there, that's not showing the whole covered porch that's also filling up the backyard. It looks kind of empty. Like, it's in the corner, but half that yard is covered in roof now within roughly 5 to 7 feet of the back line.
Agreed, but that's not a permanent structure.
Well, they sure put a lot of.
Well, I mean, it's an open structure.
It is, it's an open structure, you're
It's
right.
an open structure.
I was looking too in that, as far as unusual conditions compared with the neighbors and the fact that this was, I don't want to say wrongly, but weirdly subdivided property. It doesn't have the same flexibility as all of the neighbors, which gives the unusual condition. That's made the argument for why it's unusual. It's you looking, right there on the map, just the depth and width of the neighboring properties. It's an anomaly compared to the rest.
I think I would agree with you, except, I'm looking at this dimension, they have 47 feet of buildable area to the other side of the house. And I know there's not a bunch of houses that are wide, but a wide ranch-style house is all over East Memphis. Like, that's not an odd thing. I mean, there's 47 buildable feet to the side.
Right. But.
Wrong side of the house.
Wrong side of the house.
but it's there.
But if you look at the other houses in the neighborhood.
Microphone, please.
If you look at other houses in the neighborhood on that site plan,
Yeah, they're thinner.
they have garages, what appear to be garages in the back on that setback. So it's kind of that same typology, I guess, in the neighborhood.
I'm only seeing, just looking at the street.
Look across the street.
Across the street, I see one that goes all the way to the back, but everything else seems to be 20 feet off the back. There's the one of us directly across the street that absolutely, it's on that line.
Well, they did say the setback on the other side of the street is only 5 feet.
Yeah. It probably was per plat. Okay. Any other discussion?
So option, I'm trying to figure out what other options they could move it to the other side. Yes, that's the option, the other option. But then it's away from the driveway, and it's what? Yeah, I'm just thinking about what are the options and figuring out what's the best option. If we move it to the other side of the house, it's away from the driveway. I guess that looks like the main concern.
Mm-hmm. It definitely is not as convenient.
Yeah.
Okay. Any other thoughts before we vote?
That's a big point, though. Being on the right side takes away access to the convenience of, particularly if it's just trying to be accessible and ADA compliant. Now you're really pushing into the most furthest part from access. It would have been great to saw a physical plan just to see how these things were incorporated, so you can understand really what's pushing this 14-foot setback. But pushing it to the right side, I agree. That's going to be a wide house. So, you can make the case for both, but if you're trying to stay in character of the neighborhood, I think definitely this option is more sensitive to that. Now, on the other hand, there's a 14-foot encroachment, so it's just would you rather have a by right super wide house that doesn't really follow the character of the neighborhood, or do you keep the character from the front looking the same? Again, you're encroaching, that's not really bothering you.
In the presentation of the architect and owner, they were saying the whole purpose of the addition is, of course, the width and the turnaround. So on the right hand, the existing building already doesn't have the widths and the turnaround for the whole reason why you're building it anyway. So to put the extension on the other side, you have none of the reason why you're building it, which is the accessibility. The whole point was accessibility.
I think I'm the only one having trouble with it, which is fine. I mean, my thing to that is like, maybe this isn't the house to do this at. I mean, it might not fit. I do, like, I'm not too far away from like, wow, this is a unique situation. But I just never like it when I have a big open space that's, if I gotta rework it, that's the house I have, and that's the property I have. And the ADA stuff, I get, but like, we're looking at what's about this property to keep us from doing something. But I'm not like 100%. You guys are wrong. It's a really close call for me on whether or not I would vote yes or no on this.
I agree, because the other thing is got the money for that level of redesign and addition, then the sale relocation.
Yeah.
Yeah,
And I think the biggest thing is if we were talking about 5-foot encroachment, 4-foot encroachment, I think it would be we'll be on the same page probably across the board. I think the 14 is the biggest thing, and that's why I wanted to see more, because even if that house, I know we're accounting for HVAC and things, but even if that house shifted down some, you probably would be closer to that smaller encroachment.
Oh, yeah.
Yeah.
So I know it has the existing equipment there. You just hate to vote without having all the information, and then it votes down. But we really could have seen that was the only option if we saw like the physical layout of the space.
Mm-hmm. That makes sense. That little hallway thing, which probably could be a little mudroom or something, that's very useful. That's probably, I would guess, at least 8 feet. That's what I was. So now we're getting, instead of 14 feet in, you're 6 feet into the setback. It's a little different.
Yeah.
Yeah, but we have what we have. Any other comments before we vote?
So I wonder, and maybe somebody talked about this, that space between the proposed addition and the existing building, if you eliminate that space, push the proposed addition down to where it's flush with the existing building, then you still have an encroachment, but it's a much smaller encroachment. And I wonder why, is that what they were talking about?
Yeah, that's kind of the
And the reason why it's
idea.
not flush is because that electrical panel back there. Existing.
Oh, okay, I see,
Right.
yeah, okay.
We can vote on what we have.
Yeah.
Request more information.
Anybody else opposed to having the vote? Any more discussion needed?
I don't know. I mean, I was just thinking, even if you put the proposed addition on the front of the house, which you could do because you set back, you could come out,
Right.
an additional 20 feet. I mean, that would be more detrimental to the neighborhood, I would think, but it would be allowed.
How hard would it be to move the driveway to the other side of the house?
Well, the problem is
There's a
the house,
garage, there's, probably the kitchen.
it's the kitchen and the dining room.
Yeah, I see.
I was thinking about that too earlier. I was like, well, I moved my driveway to the other side, it wouldn't work. I started thinking about it,
Yeah.
I assume we're ready to vote. Mr. Secretary, you'll give us a roll call, please.
Ms. Conrad,
Okay, so if we vote in the affirmative, it's a good, yes.
Mr. Love,
Yes.
Mr. Bruce,
It's a tough one. Yes.
Mr. Claybrook,
Yes.
Mr. Campbell,
Yes.
Ms. Skurlock,
Yes.
Vice Chair Savage Selden.
Yes, I find that the standards of the UDC will be met and will not be unduly detrimental to the properties in the vicinity.
And Chair Rainey.
No.
Motion carries.
Motion carries. Congratulations. Hopefully it all works out well. And I believe now that's through with the cases we're going to hear. We have a few requests for rehearings. And so I believe we had a couple of council members that wanted us to flip the orders a little bit. So I think what we're going to do is we're going to, real quick, we're going to discuss 2025-70 first. That's our case on Willette. And so I think y'all probably read the information provided. What we need to vote on is, one, whether we need any testimony on whether we should have a rehearing, if we want to hear from the applicant, or the appellant. And then two, do we want to have a rehearing? So we can, first vote is, do we need additional testimony on the rehearing before we discuss if we want it? So are people wanting, I think we all got the letter, wanting to hear testimony at this time?
Shall I call the case?
What'd you say?
Shall I call the case?
Oh, yeah, go ahead and call the case, sorry. Yeah.
Item number 15, BOA 2025-70 at 1353 North Willette Street.
Okay, thank you. So with that preamble, is anybody wanting to hear additional testimony to the letters that we received? This is the case on the warehouse area that, was already kind of built right next to that house, but had been there for years, and now it's going to be a flooring place, or a place where they can keep flooring. Any testimony needed? I'm seeing not, okay. So without a call for testimony, is there anyone, do we have people that want to rehear that case?
Mr. Chairman, I think we really went through a lot of detail at that initial hearing, where we really worked through and heard all the testimony, saw exhibits. So I think, and I'm not speaking for the board, but I think we really did a good job of discussing that case and heard their testimony. So I don't think any further detail should be, this is me personally, needed at this point. I think we really went through that case very thoroughly at its initial hearing.
I agree. Other thoughts? Okay, so those in favor of granting a rehearing, so if you're in favor of a rehearing, I'd ask you to say yes. Those opposed say no. No? No. All right, the motion for a rehearing fails. Okay, so if you'll call our next case we're going to hear for the next rehearing petition.
Item number 13, BOA 2025-22 at 712 North Manassas Street.
Okay, so this is Manassas. This is our case we heard about the small little corner store there, and we heard a good bit of testimony. We've gotten a letter from the applicant on this one requesting a rehearing based on a couple things. One, he said that some of the testimony was related to a different property, and number two, he felt that his interpreter didn't show up that day, and it hampered his ability to speak to the board. So, one, do we want to hear any testimony on that case today to rehear? Is there anyone wishing to hear actual verbal testimony?
I mean, if the issue is that the interpreter didn't communicate what needed to be communicated, then I think we probably should hear that.
But that would be the rehearing. Do we need any? Do we need any? Is anybody needing any more information from? Okay, that's right. Okay, I agreed on that, and then I understand what you're saying as well. So Ms. Conrad is saying if we actually had some issues with communicating, that's probably not the way we want to conduct our business.
Agreed.
Okay, so all those in favor of rehearing the case at 712 Manassas 2025. Do we need to do this by motion? Am I doing this right, Jeffrey?
I think we should have a motion.
Okay, so let's get a motion to rehear 2025-22.
So moved.
Second. Okay, any further discussion?
I'm sorry, I stepped down for a second. We talked about this. Are we setting a precedent where, applicants can come in as they come in and say that I didn't understand, and if they don't get the answer they want, I don't understand. Just say you don't understand, and then come back and get a rehearing. Are we always setting a precedent? Is that a concern of ours?
I don't think we are, especially here. I can't remember. Were you here for the last? Yes. Like, there was communication breakdown happening that I remember.
Okay.
And that's why on this one, I get it. Yeah. Where maybe on other ones are like, no, I don't think so. But it felt a little weird to me, if that makes sense.
Okay.
When we heard that one.
Okay.
Yeah.
Okay.
I wouldn't be worried about precedent for that. Any other thoughts? Okay, all those in favor of rehearing the 2025-22 signify by saying aye.
Aye.
Any opposed? Okay, so we'll rehear that case next month. Jeffrey, do I need to go back and do we need to do a motion on the prior case? Okay.
Okay,
So-
yes, if we didn't do one.
Okay, so let's real quick, can I get a motion to rehear 2025-70, which is 1353 North Willett Street?
So moved.
Is there any discussion on that? Okay, so again, this is the Willett Street that we already sort of voted on, but we didn't do it properly, so we're trying to fix my error. But so a vote yes would rehear the case next month, a vote no would not. So all those in favor of rehearing the Willett case signify by saying yes. All those opposed signify by saying no.
No.
Okay, so we won't rehear that case. We have one more case of a potential rehearing. That's one that I recused myself on last month, so I'm going to step aside for this and hand it over to the vice chair.
Item number 14, BOA 2025-69 at 10,025 Holly Grove Road.
Okay. Same question on the oral testimony. Do we need to hear testimony today in regards to voting on whether or not to rehear this case? And I want to say that I think we thoroughly went through a lot of exhibits and testimony at the initial hearing that really kind of prompted us to vote in our way. But I will leave it to my fellow members to see if anyone needs testimony today in regards to a hearing next month. Seeing no one, no additional testimony for today for the hearing, may I get a motion on scheduling a hearing on this case for next month?
Second.
It's been properly moved in second. All those in favor of granting a hearing for next month, say aye. All those not in favor of a hearing,
No.
No.
noes have it. There will be no hearing on next month. Mr. Secretary, are there any further instructions?
No, ma'am, motion failed.
May I be permitted to ask a question procedurally? I'm interested in that matter that we just spoke of, BOA 2025-0069. What was